Hi, I'm David Heckler, Executive Editor at Corporate Counsel Magazine. I'm here at LegalTech with Dera Nevin, who's an expert on eDiscovery and a Canadian lawyer who has experience working both in-house at big companies and also at law departments. So the question I'd like to start with, Dera, is when does it make sense for a large company or even maybe a mid-sized company to think about bringing eDiscovery in-house?
It's a great question. I think it's one that a lot of organizations are wrestling with right now as they start to understand some of the impacts that eDiscovery has on the bottom line and on their own law department operation. There's no one right answer in that's a question that each company is going to have to ask for itself. And I've found in working with a number of organizations across different industry sectors that the answer can fall down to three different things, right? So what is their litigation risk profile? What types of cases do they tend to have? And is that going to stay the same, or is it projected to increase or decrease? That's one question. The second is, what is their risk tolerance? And that's both on an individual file matter and also what is their risk tolerance for eDiscovery generally? Is this a program area that they want to really manage as a business operation? And the third is to look at capacity, both internal capacity, so do they have the ability to work with their internal IT departments to expand the program, and do they have the capacity in their external counsel to really have them assist in developing out an infrastructure? And so looking at those three factors will help a company decide whether insourcing or outsourcing is the right model for them.
Now, we in the United States are fixated on litigation, hence eDiscovery is a big issue here, but what about in Canada,
Yeah. So that's another great question. Canada, of course, has eDiscovery. It shows up slightly differently in Canada than it does in the United States. Although our legal systems are very similar, there are different rules that we have in Canada which affect how eDiscovery plays out. In particular, it shows up a little bit later in the litigation than it does in the United States. And so companies might have other opportunities to resolve disputes before the production requirements really kick in Canada. So that's the most notable difference. Another major difference is that we have a number of jurisdictions across Canada, each with its own slightly different set of rules. So when you have a national proceeding, eDiscovery might unfold slightly differently across the country.
I see. Finally, I understand that you and your colleagues developed some sort of budget calculator that is useful to maybe people like our audience here?
Yeah, thank you for offering me the opportunity to talk about the work of the eDRM Metrics Committee. So I am a member of the eDRM, the Electronic Discovery Reference Model, the group that came up with the iconic model. We have a metrics group which is looking at developing a toolkit, particularly for in-house counsel and litigators to use to understand and project the cost of eDiscovery. We've recently published a number of budget calculators, which are free downloadable resources from the eDRM website. And you can go obtain those budget calculators and start to play around with the numbers on individual matters to understand what the budget might be. So those are free resources available through the eDRM website. And of course, if anybody has a calculator that they'd like us to consider and make available for publication, we're always looking for more tools and resources.
Thank you very much, Dera Nevin, and thank you for joining us.